Updated case, precedence for Allodial lands. Fraud conspiracy. Research and updated by Emilio Gora, 2025. Number 1, Rex versus Boot, 1863. Explanation of the Hawaiian government. Reference, Rex versus Boot, 1863, Hawaiian Reports, page 616644. Number 2, Hulihee versus Dennis. No one can take your lands away, applicable to Kanaka Maoli only. Applicable. Kanaka Maoli who are documented allodial title owners forever. Landowners, generational trust land owners. Note, aliens could never own allodial titles and were assigned only 30 years lease, freehold, fee simple, or lease lands. Number 3, Kapena versus John Watson. Case similar to Hulihee versus Dennis, except that it was not necessary to go to court. The only documents necessary was genealogy to the landowners, the royal patent, the land commission, and survey for grants, the grant number, and the survey. Reference, Kapena versus John Watson, Archives Files, Honolulu, Hawaii. Number 4, Iona Pi'ikoi versus John Kapena. Owner returned, occupied lands. Case was closed. Reference, Iona Pi'ikoi versus Iona Kapena, 1857, Hawaii Reports, page 1518. Kalama versus M. Kekuana'o and John Ni'i. Gardens of Victoria, Kamamalu. Evidence of ownership needed. 1. Genealogies to the original landowner. 2. Royal patent. Copies at Archives and Bureau of Conveyance. 3. LCA, Land Commission Awards. Copies at Archives and Bureau of Conveyance. And 4. Survey. See Archives. Obtain copies at the Archives. Note, if not at the Archives, see the Bureau of Conveyance. Reference, Kalama versus Kekuana'o and John E.E. Gardens of Victoria, Kamamalu. Hawaiian Reports, 1859. Hawaiian Reports, pages 202 and 209. Number 6, The King versus William Anderson and John Russell. Every fraudulent combination, mutual understanding, or concerting together of two or more to do what is obviously and directly wrongfully injuries to another is a conspiracy, and concerted together to defraud, they were guilty. Reference, Polynesia, January 25th, 1851. Also see Hawaiian Reports, 1851, Supreme Court Law Library, Archives, Main Library, Honolulu, Oahu, Hawaii. Number 7, The King versus Kahumoku, a false fraudulent alteration of a royal patent, deed, or other writing. The alteration being such as may tend to deceive and defraud any person is equivalent to a forgery of such writing. The jury rendered a verdict of guilty and sentence. Reference, The King versus Kahumoku, Polynesian, January 25, 1851. Hawaiian Reports, Supreme Court Law Library, Archives, Main Library, Honolulu, Hawaii. Number 8, bankruptcy of Ching On and Company. The landlord's claim for a rent is lien on a bankruptcy estate and has priority over ordinary debts. Reference, Hawaiian Reports, Volume 6, page 287-288. Supreme Court Law Library, Archives, Main Library, Honolulu, Oahu, Hawaii. Number 9, Riaho, U.S. President proclaimed Hawaii to be a territory and assigned judges to answer to him. Note, U.S. President Cleveland gave Hawaii back to Queen Liliuokalani twice, illegally or part of U.S. President McKinley. Reference in Re Aho, Hawaiian Reports, 1899, page 654 and 667. Number 10, Peacock versus Republic of Hawaii. U.S. became two countries. 1. American Empire territories. 2. United States, those with treaties, nations. Note, the U.S. treated Hawaii as a territory. Reference, Peacock versus Republic of Hawaii. 1899, the Hawaiian Reports, page 27 to 54. Number 11, in re-title of Pilikani case, identity theft, the Attorney General of the territory claimed that the territory is successor of the Kingdom of Hawaii. Note, only bloodlines of Kamehameha are the heirs and successors. Reference in re-title of Pilikani, 1812, Hawaiian Reports, page 175192. Aloha.